Lord Reid asked as to the trustees' knowledge of loans that had already been taken out in 2013. I ask the court to take Appendix Part 2, Volume 3, please. And beginning at MS 9745, you'll see the prospectus for this bond issue. And within that, we can go, please, to MS page 9.
What, the prospectus?
Yeah, in the prospectus. And within that, if we could go to MS page 9883. See there a table, and one sees that already as at 30th of September 2013, one looks down the table under the bold heading total state borrowings incurred. Under the line external borrowings, you see the reference to $3 billion US.
Sorry, I'm not with you.
So
there, yes, yes, I see. Yeah.
So under the heading external borrowing, $3 billion US already incurred as at September 2013. So on our construction,
I'm sorry, I haven't found it.
So if your lordship sees the table,
yes,
and then the right-hand column, you see 9 months ended 30th September 2013. You may be on the wrong page.
Oh, I am, yes.
So it's the column, page 9883.
Yep.
9 months ended 30th September 2013. And then if you look down that column, about 2/3 of the way down, total state borrowings incurred.
Yes.
And under that bold heading, external borrowing.
Ah, yes.
$3 billion US. So already as at September, the end of September 2013, in terms of new borrowings, new external borrowings, the figure was at $3 billion US.
Yes, I see.
So what this means is that we're not saying that anyone's sort of dealing with these bonds would have had to sort of dig around and find out all this, are you?
Yeah, it's in the prospectus itself.
Yeah, I know, but assume, these are tradable notes. Assume someone other than Russia acquires these notes. Would they have been expected to find out all this and discover that, in fact, there was no authority?
Yes, we do submit that. And the Court of Appeal says as much.
I know, but they may do that.
Paragraph
That seems to be fairly unrealistic.
Which paragraph of the Court of Appeal?
121.
I'm sort of concerned about apart from the extraordinary situation of this particular case, the implications of this for people dealing with foreign governments in the London market.
My only answer to that is publicly stated laws are publicly stated laws, and they say what they say. And if you need Ukrainian law advice to interpret it, then if you're incurring $3 billion worth of liability, then you do pretty careful due diligence.
Yeah, but the it is then tradable, and as O'Connell says, that I'm not saying you're wrong. I'm just saying that there are quite important implications for sovereign debt.
And all other debts, but then all these same problems would arise in relation to capacity and authority issues if you're borrowing or lending to a foreign public corporation and the like. It's not confined. These kinds of issues are not confined to state borrowing. So if our construction is right, there was insufficient headroom for a further $3 billion worth of borrowing. And one can also see how that $3 billion is made up for your lordship's interest. You see at 9891. You see how that $3 billion figure is made up at the top of page 9891. So, second line, on 28th November 2012, Ukraine issued a 1.25 billion, 7.88% notes due 2022. We can ignore that for present purpose, and then increase that issue on 6th of February 2013 by a further $1 billion. In April 2013, Ukraine issued 1.25 billion, 7.5% notes due 2023. As at 1st October 2013, Ukraine had in excess of 14.3 billion outstanding Eurobonds in the international capital markets. And then in September 2013, Ukraine was granted a loan amounting to $750 million with an interest rate 6.5% per annum under a credit facility with VTB and Sberbank of Russia, maturing on the 12th of December 2013. So, and the trustee was the trustee of the 2 Eurobonds in 2013 mentioned there. So that's how the 3 billion figure is made up. Just to conclude on Professor Butler, the handout I gave you also referred to a very short second report of Professor Butler, which is in appendix. I've given you the reference on the document. I'm not going to turn it up now in the interest of time, but it's a 2-page report, but it's very important.
Is this the one that was provided after the draft judgment?
No, this is before the court.
Oh, right.
Where is this?
So that's in our handout. It's Appendix Part 2, Volume 2, Tab 12, page 715.
And what does that add to this?
It really underlines the point, several points, but in one of the key points it makes is about the impossibility of retrospective ratification. So, in our submission, the mere appointment to be Minister of Finance involves no wider representation than the authority expressly conferred by Article 16.1 of the budget law. One simply does no more than represent that he has the authority subject to limits referred to in Article 16.1, equally the CMU. So in our submission, the Court of Appeal misunderstood the effect of Ukrainian law based on Professor Butler's report. I'm not going to spend further time on this. We deal with this in our written case at paragraphs 81 to 82. At the very least, there is an arguable matter suitable for trial, rather than the Court of Appeal simply construing the meaning of Article 16 as a matter of Ukrainian law. And I should just point out there is contemporaneous support for Professor Butler's understanding of the law. It's not something which has been made up for the purposes of the litigation. If one goes to volume Appendix 2, Appendix Part 2, Volume 4.
Sorry, volume?
Appendix 2, Volume 4. And I'm sorry, my lord, it's page 10207. And this is the expert opinion produced within the Ministry of Finance. And you'll recall from the written cases that this was in fact produced too late, after the Cabinet of Ministers should have received it. But this was dated the 19th of December 2013, you can see from the following page. But if you look at the under the heading Assessment of Effectiveness, one looks at the second paragraph under that heading on page 10207. It said it should be noted that pursuant to Annex 2 to the law of Ukraine on the state budget, the sum of financing of the general fund of the state budget by means of borrowings is set out in the amount of 129.4 billion hryvnia, including external ones of 36.5 billion hryvnia. According to the data of the Treasury, loans in the sum of 117.3 billion hryvnia, including external ones in the sum of 24 billion hryvnia, have already been made in the course of January to November 2013. Thus, should the said decree, that's 904, be adopted, the sum of borrowings, and this is further approximately 24 billion hryvnia, will exceed the parameters established by the law of Ukraine on the state budget for 2013.
Just while you have that open so we don't have to come back to it, could you just turn the page to see what he said the consequences were under legal examination?
What I should add is that this document, there isn't time to deal with it now, this document is dealt with in Mr. Pashishnik's witness statement in the bundles, and he explains the whole context of the document, including the passage Mr. Howard has just referred to, but there isn't time to go to that now. Then factually, and this is a matter again we say which was suitable for trial and not for summary judgment, let's assume against me that the Court of Appeal's construction of Article 16.1 was correct. And that the Court of Appeal was right that the relevant limit was some sort of running total. So that debts taken out in 2013 were going to be repaid in 2013, or there was a possibility of it such that the trustee was not on notice. We say, first of all, that's intrinsically unlikely given the length of the bonds involved in 2013. We've just seen in the prospectus there were long-term bond issues, but the likelihood of such repayments is inherently unlikely given the dire financial straits in which Ukraine found itself in, which necessitated borrowing from Russia in the first place. And your lordships have seen a great deal of evidence on that in terms of the background, including in Mr. Justice Blair's judgment at first instance. So the likelihood of such repayments was inherently unlikely, but in any event is a matter for investigation at trial. But in our submission, the trustee could not reasonably have assumed, even on the Court of Appeal's construction, that repayments were remotely likely to allow sufficient headroom. And we deal with this in detail in our written case at paragraphs 83 to 85. But given that the background against which the loan was taken out was that Ukraine, as the evidence shows, had lost access to the capital markets by the time it was forced to borrow from Russia, any notion of repayment is pretty unlikely, but in any event would need to be explored at trial. And the trustee obviously would have been aware of the terms of the bonds which had been issued in 2013 because it was the trustee under both of those bonds. Very briefly, the 31 earlier Eurobond issues, our reading of the Court of Appeal at paragraph 99 is that they don't attach great significance to them. We deal with this very briefly at paragraph 86 of our skeleton. But to the extent the Court of Appeal did rely on those earlier transactions, whilst it's unclear what significance they attached to us, to those transactions, we say that there was no investigation of the terms of those issuances. The trustee simply exhibited the front pages of the 31 previous issuances to one of its witness statements. And for your note, the reference is Appendix Part 2, Volume 4, pages 1005 505 and following. Sorry, I'll give you the MS reference when I have it. If they are relevant, those earlier issuances, they and their terms are a matter for investigation at trial. One cannot derive any representation from the earlier transactions relevant to the application of the budget law limits in this case without any factual investigation of the terms of those bonds. The MS reference I said I provide is 10113. The trustees' secondary case holding out by the CMU, just still pursued in their written case. We're happy to rely on the Court of Appeal's reasons for rejecting this. That is Court of Appeal paragraph 129 to paragraph 132, and we say the Court of Appeal was correct for the reasons it gave. The CMU couldn't delegate the decision to the Minister. And dealing with these residual topics quickly, we say that trustee was on, in any event, on notice of want of authority. We deal with this in our written case at paragraphs 87 to 94. The trustee has a very lengthy section dealing with why it says the trustee wasn't on notice of want of authority, some 66 paragraphs in its written case. But in short, we say when one looks at that, these are quintessential factual issues for trial, not suitable for summary determination. Then, in the time left available, could I deal with the topic, please, of reliance? Since we're dealing with an estoppel by representation based on ostensible authority, reliance is a critical feature of it. This is addressed in Ukraine's written case, paragraphs 95 to 97. And we've seen from Freeman and Lockyer that reliance is an essential feature. It's condition 3 in Lord Justice Diplock's summary of principles in Freeman. And the principal evidence relied on by the trustee is Mr. Mason Jebb's first statement at paragraph 78, which you'll find in Appendix Part 2, Volume 1. Which begins at MS 8959, and paragraph 78 is to be found at 8982.
Sorry, the MS number again.
Sorry, so paragraph 78 is at 8982.
Thank you very much.
And at paragraph 78, you see that Mr. Mason Jebb, for the trustee, says, based on my own knowledge and consultation with colleagues involved in the issuance process, Ukraine made no oral or written statements to the trustee that called into question its capacity or authority to enter into the notes. Had the trustee noticed anything in the documents which suggests that Ukraine did not have capacity or authority to enter into the notes? Had Ukraine stated to the trustee that contrary to what was said in the documents I've referred to, this was the case, then the trustee would not have proceeded with the transaction. So that's the evidence of reliance by the trustee. It's not evidence in our submission that he relied, Mr. Mason Jebb or the trustee relied on anything positively as a representation of authority. And in essence, we complain that he puts things the wrong way round. And what is critical in this context is that there is no reliance on Article 16(1) of the budget law. And that's not surprising because, in effect, the Court of Appeal reformulated the trustee's case on this matter. The trustee's claim and its evidence had never been based on Article 16(1). And we say that reliance is again a quintessential question of fact for trial, not summary judgment. And Ukraine is entitled to challenge and to put in issue exactly what the trustee relied on in creating an estoppel based on ostensible authority. Certainly no evidence that the representation that the Court of Appeal found was actively present to his mind. See the cases, I won't turn to them now, but see the cases referred to in Ukraine's written case at paragraph 96. Now, Mr. Justice Blair referred to, on reliance, this is his judgment at first instance at paragraph 168, and without turning it up, he said that the trustee gave sufficient evidence of reliance to the effect that it would not have proceeded with the transaction had it known of the lack of authority. This is the case in which detriment can be inferred from the established facts, and his lordship referred to a case called Kelly and Fraser, a decision of the Privy Council. And so far as the Kelly case is concerned, this wasn't referred to by the Court of Appeal, but it is resurrected in the trustee's written case.
I should note that reliance wasn't an issue in the Court of Appeal. That's why the Court of Appeal didn't need to refer to it. It's conceded.
No, but the point is that at that point the representation was different. The representation the Court of Appeal found against my client on is different. So one still has to establish reliance.
Sorry, I don't understand that.
The representation of the Court
Reliance wasn't an issue. You say it should have been an issue.
Well, it is now because a different representation has been found by the Court of Appeal. It's not suggested by the trustee that we can't raise the topic of reliance. It's still necessary for the court to find reliance. A whole different set of representations were relied on by Mr. Justice Blair in his conclusion on ostensible authority. The Court of Appeal has found a different representation based on Article 16(1) of the Budget Code. So we ask the question, what is the evidence supporting reliance and creating an estoppel? So to find summary judgment against, to establish judgment against my client in a summary judgment application, it's still necessary to find reliance based on the representation which has been found.
The witness tells us that we had over-representations from Ukraine in the trust deed itself that what they were doing was lawful. We'd also been provided with the letters by the legal firms to the same effect. If Ukraine, he tells us, had given us any indication that this might not be lawful, then we wouldn't have gone ahead.
That's the wrong way round. One needs to find a positive reliance on the representation which has been held to be the representation made by Ukraine.
Well, it might be thought to be rather a narrow point.
Well, it's an important one, and a $3 billion claim where my clients are being found liable on the basis of ostensible authority and estoppel by representation, then it's important to establish the relevant ingredients of both the representation and the reliance. And the representation contained, for example, in the contractual documents is only as good as the person who signed it. It's not a representation by Ukraine itself. the Minister of Finance is the person making the representation in the trust deed. He's the person who signed it. And you can't, as Freeman and Lockyer shows, one can't establish an ostensible authority by a representation from the agent himself. One needs to find a representation by Ukraine. And what the Court of Appeal said is that the relevant representation is to be found in Article 16(1). So we ask the question perfectly fairly, what is the reliance on the representation found to be the relevant representation by the Court of Appeal? One can't, it's bootstraps to say that representations are made in the trust documents because they are signed by the agent. The representation has to come from the principal himself.
Well, the document may be signed by the agent, but presumably the document is made available during the negotiation of the arrangement, and the parties are aware that this document is to be part of the contract, including the warranties that it gave. And the CMU, I think, approved at least part of the document, you know.
They approved the headline terms. One of the issues you'll see in our written case, one of the problems was that the prospectus and the terms of the detailed terms of the transaction, including the terms that have been found by Mr. Justice Blair to be onerous and unusual, were not before the CMU. There's certainly an issue on that front as to what was before the CMU and what wasn't.
But would it not be an absolutely standard term of a contract of this nature that the issuer would warrant that the agreement was legal?
Certainly, the contractual documents contain warranties and representations in
Yes.
the usual form.
Yeah.
But the contractual documentation emanates from the is signed by the Minister of Finance. And there are questions about proper authorisation by the CMU too. So the question is, what representation is there made as to compliance with Article 16? So we say that reliance does raise a triable issue, and that the evidence necessarily, because the relevant representation has changed, doesn't address the representation relied on by the Court of Appeal. There are also triable issues as to whether the trustee was on notice of the Minister's lack of authority, including whether the terms were unusual and onerous. And we do say that the application of the law in this context might well depend on the factual findings eventually made by a trial judge. And in this context, we do rely on the turn it up, but can I give you a reference? It's a judgment of the Supreme Court in the Wahid case. In the judgment of Lord Sumption at paragraph 98, which is in the Supplementary Authorities Bundle tab 2, which is MS Sup 150. It's being unsatisfactory to make findings in the absence of factual findings at trial, particularly where one is developing new areas of the law. And in that context, what I would say is that the application of the Freeman and Lockyer principles to a foreign public body in this case is novel, or indeed to a domestic public body, because what we have ended up with is that a public body has been fixed with ostensible authority where under its own laws it lacked the capacity to enter into the underlying transaction. That is the evidence of Professor Butler. No case we have found has gone this far, whether we are talking about a domestic or a foreign public body. And as a general principle of English law, we've seen from Freeman, an agent cannot have actual or ostensible authority to do an act beyond the capacity of the principal, particularly in the public law context. We say the result in this case is a surprising one, in that the minister will be found to have ostensible authority to do an act that Ukraine itself could not do under Ukrainian law. Those are decisions in novel and difficult areas which are much better reached with appropriate findings of fact made by a trial judge rather than being determined summarily. Particularly where the Court of Appeal has effectively construed Article 16 of the Ukrainian budget law for itself. My Lord, I want to leave enough time for Mr. Jaffe to deal with
Yes, of course.
countermeasures. Can I just say this, in relation to the application to admit Professor Butler's third report, I'm happy to leave that decision to be made on the papers that have been submitted to the court
Yes.
without adding anything orally.
Very well.
So, with that, if I may hand over to Mr.
Yes, thank you,
Jaffe
Mr.
to deal
Hagee.
with countermeasures.
Yes, Mr. Jaffe.
My Lords, countermeasures. Where it fits into the case is that the countermeasures defence only arises if Ukraine fails on for example, the duress argument at trial. Because if duress were to succeed at trial and the contract has been avoided, then there's no contractual obligation at all against which a countermeasure could potentially bite. So with that in mind, I propose to make three submissions. The first is that the right to take a countermeasure is a well-established right in customary international law. The second point is that the requirements for Ukraine to apply a countermeasure of non-payment to Russia are met at any view to the summary judgment standard. And just to break that down slightly, first of all, Russia has committed internationally wrongful acts which are ongoing. There are many, but one can keep it simple for the purposes of analysis. We'll just take Russia's invasion and annexation of Crimea as a working example. Ukraine is entitled, in the face of that conduct, to take countermeasures. And by countermeasures, what I mean, and I'll come back to this, is action which is short of armed conflict in order to seek to persuade Russia to cease its wrongful conduct. Then the refusal to pay is a legitimate countermeasure and is proportionate in those circumstances. Then the third submission is that contractual obligations under English law should not apply to the extent necessary to give effect to a lawful countermeasure in customary international law.
Say that again.
That contractual obligations in English law should not apply to the extent necessary to give effect to a lawful countermeasure. Putting that another way, the criteria for the reception of customary international law into the common law, which were identified and summarised by Lord Mance in KU in the passage, which I think you've seen at least 2 times over the last few days, are satisfied. Now, in his reply, yesterday afternoon, Mr. Howard actually accepted much of the substance of the countermeasures argument. And he was dealing, when he did this, with the case of a state who had made threats where those threats had been condemned by the international community and perhaps by Security Council resolutions as well. And he posed the question, which he then answered, what would happen to the English law contract in those circumstances? Well, the first thing he said, entirely consistently with his case on duress that Mr. Thankey has already dealt with, is that the English law of duress would not apply in those circumstances and would be unaffected. Well, we've already dealt with that. Then he accepted, and just reading from the transcript yesterday, it's page 145, he said, what it would probably result in that situation, where you had an English law contract, is the English court refusing to give effect to the contract. The reason for that would be the UK is obliged, under the UN Charter, as it was in Q8, to give effect to the resolutions, and it would be inconsistent with the resolutions to allow enforcement of a contract which the Security Council had said had been obtained by the improper use of force. Well, really, that is the countermeasures case in a nutshell. It's accepted by law Debenture that the common law can and should, in appropriate circumstances, respond to internationally wrongful conduct by adjusting obligations in the law of contract.
Is that based on the common law, or is it based on a statutory obligation under the United Nations Act to give effect to Security Council resolutions?
If there is direct incorporation and there is an obligation to comply with a particular requirement under the United Nations Act, then there's no question there. But what Mr. Howard was accepting was not a statutory obligation, but the response of the common law in those circumstances. It's a form of incorporation because of a requirement of customary international law. It wasn't said that, well, look at the United Nations Act, there's a statutory duty to do this. Instead, what was being said, at least as we understood it, was the straightforward point that the common law would have to respond to that degree of internationally wrongful conduct.
Thank you.
Now, whether that's what he was saying or not, that is nonetheless our case. That customary international law, there is a presumption that it will be incorporated into domestic law where it's constitutionally appropriate to do so. And those constitutional requirements are satisfied in the circumstances of this case. So just to elaborate on those 3 points a little, first of all, whether or not countermeasures are part of customary international law. They are, in my submission, very well established as a proper part of customary international law. The quickest place to take this from is from the International Law Commission's draft articles on state responsibility. They're in the authorities bundles at bundle 21, tab 212, MS 7966. The relevant principles relating to countermeasures start at Article 22 on MS 8011.
Sorry, page again.
8011, my lord.
Thank you very much.
So the text of Article 22 is that the wrongfulness of an act of a state not in conformity with an international obligation towards another state is precluded if and to the extent that the act constitutes a countermeasure taken against the latter state in accordance with Chapter 2 of Part 3. So that's the encapsulation of the principle. Then the commentary is helpful. I'm not going to read it, but summarising it, paragraph 1 of the commentary explains that the purpose of countermeasures is to procure the cessation of wrongful conduct and to take reparation for injury. Paragraph 2 sets out the legal basis in public international law, and the leading case is the Gabsikovo-Nagimaros project case, where the ICJ recognised countermeasures, and then there are numerous examples of arbitrations where the legitimacy of countermeasures have been recognised. They're cited in detail in paragraph 2 and in the footnotes. Paragraph 3 explains that this concept in international law used to go under a number of different names, like reprisals, self-protection, self-help, and so on. The effect is dealt with in 4, and the effect is to temporarily relieve a state from compliance with an obligation. And under 5, the countermeasure obviously has to be directed against the recalcitrant state. Article 22 then refers to Chapter 2 of Part 3. So we go there next. That's on MS 8064. And if I can pick it up then at page 8065, looking at Article 49. Article 49 repeats, in essence, Article 22. It's the right to take countermeasures. 49.2, they're limited to the non-performance for the time being of international obligations of the state, taking the measures towards the responsible state. And then 3, where possible, they're effectively to be temporary, so that the obligation can be resumed. Then Article 50 on page 86.
Before you move on, we're talking here about international obligations. How does that impinge on?
The relevant international obligation is, for example, the annexation of Crimea by Russia.
Yes, countermeasures are limited to the non-performance of international obligations of the state taking the measures towards the responsible state. So, international obligations of Ukraine. How does that fit in with your case?
The obligation here is solely at present an obligation under municipal law to pay. But ordinarily, and it's common that such topics are referred to international arbitration, and they are considered between states to also give rise to obligations between themselves. So in those circumstances, if merely because the obligation is also in a contract, to say that Ukraine cannot avoid any taking any countermeasure merely because it's a municipal contract would not be an appropriate reason. Because otherwise, the fact that something is also in a contract would mean that a legitimate countermeasure would be however appropriate or sensible it is. Article 50.
And this is a particularly unusual case because it's not even an obligation owed to Russia in contract. It's an obligation owed to an English PLC administering a trust of which Russia is the current beneficiary.
Yes, that's right. And the countermeasure has to be properly directed at Russia. And so if, for example, the notes had been traded and, for example, sold to a pension fund, it may be, as a matter of public international law, that it would not be proper to take a countermeasure in those circumstances. That would be a matter which a court would have to consider when deciding whether the countermeasure was properly directed at the recalcitrant state. Here, of course, the notes are beneficially owned by Russia through the trustee, and any countermeasure would solely have an effect on Russia. If it were different, then the court might have to take a different approach. Article 50 sets out the limitations on countermeasures. Obviously, a countermeasure can never encompass the threat or the use of force under 51A, a breach of fundamental rights, obligations of humanitarian character, or obligations under peremptory norms. And in any event, dispute resolution procedures have to be complied with, and you can't violate diplomatic premises. Then, finally, and perhaps most importantly, Article 51 on page 8070.
Sorry, just before we leave that, I'm just looking at in the commentary, paragraph 4.
On which page, Mark?
On page 8066, it just caught my eye that line 5, the word only in paragraph 1 applies equally to the target of countermeasures as to their purpose, and is intended to convey that countermeasures may only be adopted against a state which is the author of the internationally wrongful act. Countermeasures may not be directed against states other than the responsible state. And then it goes on to deal with the situation where a third state is owed an international obligation. But it's clearly, well, it certainly seems to be talking about obligations owed, as it says, international obligations owed by one state towards another.
My submission is that that must also apply to a countermeasure which affects a municipal law obligation, because if it were otherwise, then the legitimate scope of countermeasures would be far too narrow. And the reason for that is that the purpose of a countermeasure is to allow a state to do something in response to a serious breach of international law, where the state's response is something short of armed conflict. In other words, as an alternative to a resort to the use of force, a state can take lesser measures. And it might be better characterized, for example, by way of calling it a sanction. That in response, for example, to the annexation or the purported annexation of Crimea, the legitimate response in international relations of Ukraine is non-payment, and call it a moratorium, call it sanctions. Don't worry about the fact that there is also sitting beneath it a municipal law contract, but the response on the international plane is one of a sanction of non-payment. And so there is an international obligation which is there as well, which is being imposed in my submission. Because otherwise, for example, if there were purely private law contracts to which sanctions were applied, then a countermeasure of sanctions could never be taken. And of course, a sanction is a classic countermeasure. One takes sanctions against a country as a better and lesser alternative to resorting to war with that country. So this is an unusual situation where there is a municipal law contract. But the possibility of a countermeasure is, in our submission, equally available in this circumstance. Article 51 is proportionality, which is, in effect, a statement of the obvious. So, turning then to my second submission of whether or not the requirements of public international law are at least arguably met in this case, needless to say, countermeasures are not limited to pre-contractual conduct. So, annexation of territory after the bond issue might be a proper basis for countermeasures. And it is at least arguable, putting it at its very lowest, that Russia's conduct in, for example, purporting to annex Crimea was and remains a flagrant breach of Jus Cogens, the prohibition on the use of the threat or the use of force. If authority is needed for that, I'll just, if I may, give you some references. The UN General Assembly's statement that Russia's purported annexation was unlawful in international law is in Authorities 21 at tab 229, MS 8244. The way the General Assembly put it is they made an affirmation that the seizure of Crimea by force is illegal and a violation of international law. The United Kingdom's view is equally clear.
There's no Security Council resolution, as I understand.
There's no Security Council resolution. And the difference between the view of the General Assembly and the view of the Security Council, my Lord, of course, knows that only the Security Council can authorise action under Chapter 7. So, for example, action perhaps by the use of force in order to restore the previous situation. However, there is nothing to stop the General Assembly making a statement of its view as to whether or not there has been a fundamental breach of international law. What the General Assembly can't do is order the troops in or give permission under international law to do that. Vetoed every attempt at a Security Council resolution, but that has not prevented the General Assembly from making an equally clear statement to that effect. And that perhaps brings us back to the Kuwait issues that were discussed yesterday. Does it matter that, for example, Russia is able to veto a Security Council resolution? Is it still a breach of Jus Cogens in those circumstances? Well, our submission is, of course, yes. But at this stage, of course, I only need to seek to persuade the court that there is an arguable case of a breach of a Jus Cogens obligation, and in my submission that can clearly be done. Just the references to the United Kingdom's view, the current Prime Minister set it out in Volume 5 of Part 2 of the Appendix, that's MS 10600, and the previous Prime Minister, MS 10589.
Assuming for the sake of argument that this raised a justiciable issue, the court wouldn't be bound by the views either of the General Assembly or Her Majesty's government.
Say there's a triable issue on that question. That's as far as I'm seeking to persuade your lordships of at this stage.
The court would have to, I suppose, carry out its own, make its own assessment on the basis of the evidence led.
And that's the difference which was discussed in argument yesterday as a result of Belhage and Lord Sumption's comment, which was also points that were made by the Court of Appeal, that where there is a factual dispute about a breach of international law, which goes to an issue before the court may need to resolve it. And there's no difficulty in doing that. And that was a case, for example, in Belhage, there were disputes as to whether or not grave international crimes, such as torture, had been committed by friendly foreign powers. And those were matters that this court sent to trial. As to proportionality, the arguable case is simply that a large proportion of Ukraine's territory and productive economic capacity has been annexed by Russia. The evidence for that, again, I don't need to go for it, is in the documentation requesting all creditors to agree new terms for their lending, where all of that is set out, and that's MS 10473. But again, it's a statement really of the obvious. So the third set of submissions is whether or not a legitimate countermeasure in public international law should be recognised by the common law. And that is a question of incorporation into domestic law, unlike the duress argument. As the court knows, the modern view, and it's a view which Ukraine submits is correct, is that customary international law is not automatically incorporated into domestic law without more. But it is a valuable source of the common law, and there is a presumption, subject to compatibility with our own constitutional arrangements, that customary international law will be incorporated into domestic law. I'm not going to take you back to paragraph 150 of KU, because you've seen it before, but I will, if I may, show you the recent decision of the Court of Appeal in the Freedom and Justice Party case. That decision is in volume 2 of the authorities at tab 12, MS 915. The issue in this case was whether or not the common law should recognise the customary international law existence of special mission immunity to any criminal charge, including allegations of torture, so very serious allegations. Lord Mance's dictum in KU was applied by the court. If I could pick it up at MS 943. At paragraph 114 of MS 943, the Court of Appeal adopt Lord Mance and KU, and then at paragraph 116, the Court of Appeal summarise the principles in their own words. The presumption is that a rule of customary international law will be taken to shape the common law, unless there's some positive reason based on constitutional principle, statute law, or common law that it should not, and they refer to these as constitutional principles for ease. And that reflects the policy of the common law, that it should be in alignment with the common customary law applicable between nations. Then they explain that's different from treaty obligations, where different principles apply, which are considerably stricter principles. Then moving on to paragraph...
That paragraph alone might import a whole battery of issues in relation to non-justiciability.
And I will deal with the non-justiciability argument, because I know that was a point which was raised in the Westland Helicopters case, where countermeasures was raised. And I think it's the only case, remains the only case, apart from this one, in which a countermeasures argument has been run. And I'll return to that in a moment, if I may. I will deal with it.
Can I ask you what, in terms of Lord Mansell's obiter dictum, what common law rule is it that the courts can sensibly adapt in the light of the customary international law?
The rule that can be adopted is...
Adapted.
Well, I think the rule which the court can adopt is that...
No, but he's not talking about adopting rules. He's talking about international law influencing the development of a common law, and there has to be a hook to hang it on. Say
Use
customary
the word
international law
Yes.
should shape the common law wherever it can do so consistently with, for present purposes, common law rules which the courts can themselves sensibly adapt.
So to give an example from the facts of the Freedom and Justice Party case, the common law has in the past and continues to recognise certain immunities for persons who act on behalf of other states. Now, diplomatic immunity is now codified in statute. Special mission immunity was not dealt with in statute. What the court decided to do in the Freedom and Justice Party case is recognising that the concept of an immunity was one that the common law recognises, that it would extend that immunity to members of a special mission who had been approved as members of the special mission by the Foreign Office. One can call that an adaptation, or one can call that a creation of a new immunity, depending on which side of the case you're on. But nonetheless, what's being done is a substantial development of the common law to recognise a principle or a requirement of customary law into our own legal framework, provide defence to a serious criminal charge.
One of the domestic constitutional principles which has to be borne in mind is that the courts don't have a legislative function. We have to develop the law, as people say, incrementally on the basis of established principles. So I'm just wondering what's the hook that we hang this on?
The hook that it can be hung on is that it provides a legal basis or a defence for the temporary non-performance of the contractual obligation.
Right.
In Freedom and Justice, the conclusion was that the Divisional Court was correct to hold that a rule of customary international law has been identified which now obliges a state to grant to the members of a special mission, which is accepted and recognized as such, immunity from arrest or detention. So there was an international obligation in that case which gave rise to the adaptation of rules of national law.
Adaptation of common law in order to recognise on the international plan.
There was an obligation to do it in that case.
Well, there was an obligation to do it in that case. And I don't go as far as to say there is an obligation to do it in this case. However, it remains lawful conduct, and the analysis which I've given by Ukraine. Question is then whether or not the court should, despite Ukraine's lawful conduct on the international plane, enforce the contract. The effect of that, and there's no point in being subtle about it, is to entirely frustrate the countermeasure. So the countermeasure then becomes of no legal effect if the municipal court enforces it, totally frustrates it. And so in those circumstances, the mechanism provided by international law to avoid resort to armed conflict, the lesser measures which are permitted in response to an outrageous breach of public international law, are being frustrated by the municipal court. So I don't go as far as to say that there is an obligation in customary international law to receive this, and I don't need to. because customary international law is often received without there being a specific obligation to implement it. But the consequences of not doing so are, in my submission, very significant. And that's why I say the court has a choice, and it is unashamedly a public policy choice, as to whether or not to receive that principle of public international law into the common law, and it's a choice which the court ought to make with the answer of yes. Now, the court should do it carefully and appropriately incrementally, looking at the facts of this case and saying that it is potentially arguable that...
The countermeasure is something that the Ukraine is doing, isn't it? What is it doing on this occasion?
Non-payment.
Non-payment. So you then come to the domestic contractual position. The court is faced with a apparently valid claim to enforce under a apparently valid contract. And how does that, what Ukraine says it has done, i.e. not paying, feed into your sort of Cheshire and 5-foot domestic remedies?
If you want to give it a domestic name, it has a close relationship to existing domestic concepts of self-help and set-off, justification and frustration. And those were examples.
That's quite a...
Those were examples the Court of Appeal gave when discussing what the international law doctrine of countermeasures were.
Well, the contract obviously isn't frustrated. And insofar as you might be relying on mutuality of obligations, there's no... I mean, it's not mutuality of contractual obligations, but mutuality as a sort of version of it, where it's non-performance of a contractual obligation as a in response to you say the breach of an obligation under public international law owed by. I mean, it's non-performance of a contractual obligation owed to the trustee because of the alleged breach of a public international law obligation by Russia.
Put it simply, under the banner of public policy. There are lots of ways to fit it into domestic law and common law concepts which already exist. Now,
I'd be helped if you could point me to the closest one, which sort of fits. And I use Cheshire and 5-foot in a way as a sort of, I was pointing out, I was looking for some way in which the very well-established principles of contract law can be adapted to bring this into it.
Set off self-help or public policy as a temporary basis for non-compliance.
Set off self-help public policy.
But KU does not require you to give it an existing domestic title. The common law, wherever possible, will seek to develop by analogy. And the common law already recognises that there may be reasons or a basis for temporary non-compliance with a contractual obligation. The question is whether it's a satisfactory thing to do within our constitutional framework in order to accept or adopt that. So I would invite the court not to get overly concerned about the exact title which is given, just as one didn't get too concerned in the Freedom and Justice Party case about exactly how it's implemented. What the court did in that case was, if anything, much more striking than what is being proposed here. The court recognised a new immunity which had no statutory basis in circumstances in which Parliament had already legislated in a very closely related field, namely diplomatic immunity, and had not provided any special mission immunity. My Lord, Lloyd Jones is querying that, but...
Well, I am, because it was clearly outside the scope of the legislation on diplomatic immunity and the international conventions on diplomatic immunity.
I'm certainly not suggesting that any part of that decision was wrong, but I am suggesting that the question of immunities for officials of foreign states was a matter which had been considered by Parliament previously. Special mission immunity hadn't been included. And as an example of the common law taking a substantial step, and not one which I say is wrong in any way, to receive customary international law into common law to provide a defence to a serious criminal charge. It's a good working example of that type of reception of customary international law. That's why I rely on it. Just to complete the points that I was making on Freedom and Justice Party, just a couple of other paragraphs to refer you to, if I may. Paragraph 120, which is on page 9 for MS 945. The court distinguished between creating a new crime, which is not permissible, Margaret Jones, and creating a new immunity, in effect a defence, reflecting those which already exist in customary international law. And that's what the court was prepared to do in that case. Paragraph 121 deals with the arguments that were put forward and rejected for saying that only Parliament could give effect to a new immunity. And then paragraphs 125 and 126 deal with the points which my Lord Lloyd Jones just made to me about the extent of the parliamentary interventions in that area and whether they could be said to have occupied the field. And the Court of Appeal's conclusion was that they had not occupied the field. So therefore there was no concern on that front in that case. Now applied here, the law of contract remains a substantially common law endeavour. Parliament hasn't created an exclusive code, and there is no reason why the common law can't continue to develop appropriately to recognise a potentially lawful countermeasure as a defence to an allegation of breach of contract. I said I would go also to the Westland Helicopters case, which is the only authority which Ukraine is aware of where a countermeasures argument has been pursued. It's a first instance decision, and it's in Authorities Volume 18 at tab 173. MS 7086. This case is really an international law version of Shergill. Following a dispute between the members of the Arab Organization for Industrialization, the issue for the court was who the true representative of the organization was. Was it a body in Cairo, or was it a rival body in the Gulf? And the underlying issue was who owned all the money that was on deposit at various banks. That was why it was important. The argument that was run on countermeasures is dealt with by Mr. Justice Coleman at MS 7111. It's all obiter because it was decided, the case was decided against the Cairo body, which claimed to be entitled and a true representative of the organisation on other grounds. But at 7111 at letter D, the issues are identified, and issue Roman 2 between D and E is whether in the circumstances of the conduct of the three Gulf states there was any principle of justifiable response or necessity in public international law which would have justified Egypt in taking the course it did in passing law number 30. And law number 30 was an Egyptian law essentially taking control of the organisation. Then at letter H, at the bottom of 7111, Mr. Brownlee, who was acting on behalf of the Egyptian version of AOI, set out his submissions. And what he argued was that Egypt's conduct in response to the Gulf states pulling out of a treaty body was an entirely legitimate countermeasure. And that's set out expressly by the court at 7112, just before C, where Mr. Justice Coleman says, fundamental to Mr. Brownlee's submission is the premise that the three Gulf states committed a material breach of the treaty by their non-participation. Egypt was entitled to ignore that breach and unilaterally to take lawful countermeasures to avoid the paralysis of AOI. Then the response is given by Mrs. Higgins, and her submission, which is between C and D, is that the doctrine of necessity became applicable only in cases where physical danger was contemplated, and then nowhere had it ever been suggested it was open to a state to resort as a countermeasure in its own domestic legislation to change the constitution of an international organisation whose seat was in the territory of that state. So unabashedly an international law response to the allegation of countermeasures. Then the judge's conclusion is between E and F on the same page. Because of the principles of non-justiciability, an English court can decide neither issue A nor issue B. Such issues can be decided only by reference to public international law, by a public international law forum, and not by an English municipal court. For both issues necessarily involve the determination of whether foreign sovereign states are acting consistently or inconsistently with the rules of public international law. So it's unnecessary to consider it further. Now, whether that analysis is right or not, it predates the decision of the House of Lords in Kuwait Airways by 7 years. Here, as in Kuwait Airways, the view of the international community is entirely clear, and the extent of the principle of non-justiciability in the face of a flagrant annexation of territory is one which is different in our modern understanding of the law. So there is nothing in Westland which rejects the reception of the doctrine of countermeasures into the common law. And it is notable that Mrs. Higgins, for Westland, made her submissions based on the inapplicability of the international law principles. The judge's decision was on the basis of non-justiciability, and that's a decision which has no application in my submission to the circumstances of this case, which are on all fours with the decision of the House of Lords in Kuwait.
So you say it would not be decided the same way?
That case may well be decided the same way, but the question of whether or not a countermeasure should be recognised would not fall on a non-justiciability ground. And it's understandable and correct that it was argued on the basis of the substantive principles of public international law by Westland in that case. The submission, my lords.
Yes, I see that. You're not surprised that Rosalind Higgins was taking an international view of international law view of matters. She was led by Stanley Burnton QC, who doesn't seem to have come into this particular point. So maybe that explains it all.
Now you are getting very close to your time limit, Mr. Jeffy.
The good news is, with a sentence or two, I'm finished. I simply say that the countermeasures defence shouldn't have been summarily disposed of. Unless I can assist further, my lords, those are my submissions.
Thank you. Thank you very much, Mr. Jeffy. Ms. Howard.
The more unrealistic and unmeritorious the position appeared. But his submissions, if correct, are not only unmeritorious and unrealistic, they would have grave consequences for English law and for London's position as an international financial centre, where bonds and other instruments issued by sovereign states are traded on a daily basis. Mr. Thankey is wrong in his submissions, firstly because capacity is simply a matter of English law, and in English law, states such as Ukraine have unlimited capacity. Secondly, as to authority, because, very simply, Ukraine held out the Minister of Finance as having authority to issue the bonds and provide the representations and assurances that he did, and a reasonable person in the trustee's position would have no reason to doubt it. And I will refer you tomorrow to the decision of the Privy Council earlier this year in, I think it's the P.T. Satria case, in which I think 3 of your lordships were present and in which I was counsel. Briefly on the countermeasures point, obviously I will come back to that tomorrow, but you will note that the Court of Appeal said that very little time was spent on that at the hearing, and as they put it, for good reason. That's paragraph 187. The good reason was that they regarded the point rightly as hopeless as a matter of English law. To come back to the capacity point, which I will endeavour to deal with in the course of the remainder of the afternoon. Ukraine contends that it did not have capacity to enter into the notes as a matter of Ukrainian law. Now, the Court of Appeal noted at paragraph 37, Ukraine's allegations will not affect its capacity unless it can be shown that questions of capacity as a matter of English conflicts principles are to be governed by Ukrainian law. So ultimately, the key question is Ukrainian law in relation to the capacity question of any relevance? We respectfully submit that it is not, essentially for the reasons given by the Court of Appeal, which can be summarised as follows. Firstly, as a matter of English law, the legal personality of a state derives from its recognition as a state by Her Majesty's government. That carries with it unlimited capacity, including capacity to contract. This makes perfect sense because the capacities of an entity are determined by the legal system which clothes it with legal personality. Secondly, there is no analogy to be drawn, as Mr. Thankey submits, with subordinate entities like foreign corporations or foreign municipal authorities. And that is so for a very simple reason. Those entities are created or constituted by the foreign sovereign. By way of contrast, self-evidently, the foreign sovereign does not create or constitute itself. Accordingly, Ukraine's internal laws are irrelevant as a matter of English law to the capacity question. That does not mean they are irrelevant in toto. They are, of course, relevant to the authority question, which we'll come to separately. Now, Ukraine's approach, looking at its internal laws, is incoherent in any event, in that they appear to say that provisions of internal law that are fundamental or constitutional or breaches that are flagrant are what are relevant. But it's very difficult to see any principled basis. Now, what is common ground before the court is that we are concerned with an issue of domestic law. But as the Court of Appeal noted, as a matter of international law, which deals with states on the international plane, states do have unlimited capacity. Now, it would be surprising, is what the Court of Appeal said, and I submit they are right, if the English common law did not produce in this area the same result as public international law. And indeed, the Court of Appeal said if it didn't, that would be a strong case for re-examining the position at common law, see paragraph 73. Thus, whilst the rules of public international law are irrelevant in the sense of not being determinative, they certainly firstly support the trustee's position, and secondly they act as a sense check in the manner suggested by the Court of Appeal. Now, before developing these points, it's also fair to point out at the outset that Ukraine's approach would produce extreme and unfair results. And the first is a state might, according to Ukraine, lack capacity because of a secret law. Now, the secret law wasn't something we made up. It's Professor Butler who says Ukraine, he says it about Ukraine and Russia, but it's Ukraine that's relevant. He says the whole nature of Ukraine is that they have laws which are secret, which you can't determine, which are part of the constitution. That's a fairly, to us obviously as English lawyers, that's a fairly remarkable feature. But the fact that you do have states which have laws which are part of the constitution, which are unknowable, is a factor which would mean that Ukraine's arguments could have rather dramatic effects.
You have a reference for that, please?
To Professor Butler.
Yes.
Can I give that to you? I haven't got it at this stage in my note.
Thank you very much.
I'll find it in a moment. The second thing is, a state might unilaterally change its own capacity, including retrospectively for this purpose. But leaving aside these difficulties, what this case shows in relation to the type of arguments that are run is that you can have a situation where every single organ of the state has acted on the basis that what is being done is lawful and within the Constitution. But you then have, and that's actually what's happened in this case, you have Professor Butler pops up 2 years later, and obviously if the matter goes to trial, these are going to be issues we will explore in cross-examination with him. But he pops up 2 years later and says, well, I can tell you, notwithstanding what the Prime Minister, the CMU, and all others thought, actually this is in breach of the Constitution, and so an English law contract in relation to bonds being traded on the London market is void. Now, in our submission, obviously if that is the state of the law, that's the state of the law, but it's an extreme and unsatisfactory position for English law and for potentially the London markets. The reference, my Lord, is in Butler 1, which is in Appendix Part 2 at paragraph 1311, and it's MS 9198.
Thank you.
Volume 1 of Appendix Part 2. Now, in our submission, the trustees' submission and the Court of Appeal's approach produces a result which is coherent and consistent with public international law, whilst also giving effect to the internal law of a foreign state as rules relevant to actual authority of its agents to act on its behalf. So if I turn to the first point, the legal personality of a state in English law derives from its recognition as a state by Her Majesty's government. You see this point made in the Court of Appeal's judgment at paragraphs 54, 63 and 71. I can just...
Sorry, the paragraphs again?
54, my Lord,
Yep.
63 and 71.
Thank you.
I don't need to read them out if I can just remind you of those paragraphs. Now, in our submission, those paragraphs are plainly correct. There are
Is it right, Mr. Howard, that personality derives from that capacity derives from personality?
Sorry, could you?
Is it right that capacity is derived from personality?
Well, what
It
they're
flows naturally from it?
What they're saying is that the position in English law is a foreign state which hasn't been recognised, doesn't have any standing, as it were, it doesn't have any characteristics. Once it has been recognised by her government, by Her Majesty's government, the effect of that is to constitute, in English law eyes, the state. So it's that which gives it personality as a matter of law. That's all. It's the personality. What they're saying is flows from the act of recognition by Her Majesty's government.
Yes. Is capacity then derived from
Yes.
the fact of personality?
Well,
because
then
looking at the Tin Council case this morning, it occurred to me that the House of Lords there actually seems to be saying that it flowed the other way. Because they've got capacity, they must have a legal personality.
Yeah. Well, I'm not quite sure. What are you saying? Is it a chicken and egg situation which comes first?
I'm questioning whether it is necessarily the case that the existence of legal personality provides an answer in relation to what are the capacities of the person.
Well, it doesn't necessarily. Then you have to consider, the first question is, how does this entity, the state, become recognised in English law? How do we actually recognise it as a legal person?
I understand that so far as personality is concerned, that flows from the fact of recognition by Her Majesty's
Then one has to ask, having recognised it as a matter of English law, what capacity as a matter of English law do we give it? And that's a separate step in the inquiry.
Yes, that's my point. That's my point.
Yeah, no, it is a separate step in the inquiry, and that is what the Court of Appeal are dealing with that in their judgment.
Well, they pick it up at 71, I think.
Yeah.
Having dealt with the issue of personality, they come to the question of capacity really at 71, I think.
Yes, and the point that the Court of Appeal are making, which is that once you've given them personality, the question is, as a matter of English law, does a person who has been recognised in that way, does he have any limits on his capacity? And the point is, as a matter of English law, the answer is a person so recognised doesn't, because a person has unlimited capacity unless you can find something about either in the Constitution where you've set them up, in other words, by the act of recognition, or it's you're recognising some foreign entity which itself has in its Constitution some limitation. It's the point is, and that's the point they make at 71, that in the next sentence, that there's no prerogative or statutory authority for limiting the capacity and powers enjoyed by a foreign state, which has legal personality. It follows from the absence of any limits at common law, thus, as a matter of English law, the foreign state enjoys limited capacity. And that's why it flows from recognition of the personality at common law. Having recognised the personality, you then have to say, at common law, what are there any limitations on its capacity? The answer is no. And so there are 3 points that the Court of Appeal make. The first is that the acceptance of a foreign state as a separate legal person evolved from the common law's approach to the recognition of the sovereign power of monarchs. Secondly, that it's well established that the government as the executive has the prerogative power to determine whether or not to recognise a foreign state. And thirdly, the act of recognition is itself constitutive in the sense that it creates the person on the domestic plane. So you can see the evolution of this is explained in the Court of Appeal at 55 to 61. And I don't think I need to say very much about that, but it all goes back to when most states were monarchies. There was obviously no difficulty in accepting the monarch had legal personality. And the well-known case here, which they refer to in 56, is USA and Wagner, which is, for your note, I don't think we need to turn it up, it's in Authorities, Volume 3, tab 21 at MS 1302. And I think the Court of Appeal, they quote from the Lord Chancellor and from Lord Justice Turner at the top of, in paragraph 56, and from Lord Cairns, and in our submission, those are instructive paragraphs. And then at 61, the Court of Appeal noted that the character in which the rights were held didn't change when there was a change in the constitutional arrangements within the state, such as when you moved from a monarchy to a republic. Then the next point, Her Majesty's government prerogative, power of recognition. We saw that you can see that in the Court of Appeal at 57 when they referred to Lord Justice Turner, and it's, in any event, in the modern world, it's clear beyond any doubt that it's part of the prerogative of the executive branch of the government to decide who to recognise, and that the sovereign has the absolute right to direct the answer. The jurisprudence, or these principles, were summarised in a case called Mohammed and Brish in 2019, which is in volume 11 of the authorities at tab 108, MS 4549, at paragraph 32 of Mr. Justice Andrew Baker's judgment, but I don't think we need to turn it up. So the final point under this heading is that recognition is constitutive, and we see that in the Court of Appeal at 54, 63 and 71. And as the Court of Appeal themselves say, all the well-known writings on this have recognised it. It might be worth just turning those up. So could I ask you to take volume 20 of the authorities. And Professor Mann is at tab 200, which is MS 7720. And just on that page, in the first paragraph, you can see he starts off by talking about the Carl Zeiss Stiftung case, and about 10 lines down, there's a sentence where he says, "In law, therefore, the non-recognized state does not exist. It is, if one prefers so to put it, a nullity." And he goes on to say, of course, we all know that in fact, or in the real world, there is such an organization as, say, the Turkish Republic of Cyprus, but in English eyes it does not exist. To a lawyer, this isn't an unfamiliar situation. In law, a contract may be null and void and unenforceable, but in fact it may have been concluded and performed. And in the same volume at 202, we have Dr. Marston's article on the personality of the foreign state in English law, and at MS 7760, at the foot of the page, identification of the entity on which capacity is confirmed, having seen that it's executive recognition which creates capacity for a foreign state to act at the plane of English law, it's now necessary to identify more precisely the body politic on which that's conferred, but there he recognises that it's English law through recognition which creates capacity. And at 7771, top of the page, or it might be worth just picking it up at the bottom of the previous 7770 under the conclusion that the factual trigger for the English court's acknowledgement of foreign states as legal persons was the emergence of non-monarchical bodies, politic in the early 19th century litigation. The courts left to the executive the tasks of determining both the criteria of statehood and whether they were fulfilled. Where the executive had decided to recognise a foreign body politic as a state, the courts regarded it therefore thereafter as a legal person, notwithstanding that in the Vice-Chancellor's words it was not a physical but a metaphysical entity. executive recognition was therefore not only acknowledgement of the foreign state's international legal personality, but was constitutive of its personality. And Professor Shaw, Malcolm Shaw...
Does he deal with the question of capacity as distinct from personality or not?
No, not separately.
Save in that earlier sentence that
Save in that.
7760,
Yeah.
to which you referred.
It is worth just well, we've seen the Tin Council case, and I'm going to come back to that in a moment. But the important point in the Tin Council case, just to remember, was that the argument was that the members were liable for the debts. It's actually, let's perhaps quickly turn it up now. It's in volume 2 of the authorities, and at tab 7. And Mr. Thankey took you to pages 569 and 570. Slightly oddly, he went to 570 first and then back to 569. The reason I say slightly oddly, if one analyses what Lord Oliver is saying, is that at 569, between B and D, the argument that was being made, if one looks from B, is that related to the effect of the order in council. So in the second sentence, he says it will be recalled this designates the primary objective of the agreement as that of enabling the council and so on. And for this purpose, it was argued it was no doubt necessary to provide a convenient method of, for instance, engaging in legal proceedings, but this can conveniently be done by conferring on the unincorporated members certain capacities so as to enable them to function in the name of the ITC. It wasn't necessary to invest it with separate legal personality, but there are a number of difficulties in the way of that suggestion. In the first place, the members were sovereign states recognized in English law and already having capacities as such, so that an order in council which conferred on them capacities served no useful purpose. Now just stop there for a moment. Mr. Thankey's submission is that each state's capacity is defined by its own internal laws. So if Mr. Thankey's submission were right, the order in council would have served a useful purpose, because the order in council would have made each state having unlimited capacity for the liabilities of the Tin Council. But the point is, so what Lord Oliver said would have made no sense at all against Mr. Thankey's submissions. The order in council would have served a very useful purpose for the purpose of this argument that was being made, because it would have meant that each state was then treated as having unlimited capacity, whereas previously such capacity as they had per Mr. Thankey is according to their domestic law. And so the whole premise of what Lord Oliver is saying is entirely consistent with our position. Now, in relation to the Tin Council itself as an international legal person, what the case also shows is that English law determined what its capacity was, it having been recognised as a matter of English law through the Order in Council. And so we say the same approach here should be applied to a state. Now, that then leaves on to the next point, which is the one that we've already seen, that English law imposes no restrictions on the capacities of those who have legal personality, save pursuant to statute. And so the Court of Appeal make that point at paragraph 65 of their judgment. The consequence of legal personality in domestic law is the person can do all those things for which legal personality is required. And the judge was right, they said, to say that capacity flows from personality. And at 66, they explain that leaving aside sovereign states, there are the only type of legal persons are individuals and body corporates, or if you like, it's also individuals, body corporates, and sovereign states. And they explain, and that's the purpose of the paragraphs that follow, how either a corporation or a person can have limitations, and essentially it's only through statute. And so there's no limitation on the capacity of individuals and corporations in English law. Individuals, you'd have to have an individual under a disability. And at common law, there's no limits to capacity. See paragraph 67. The relevance of companies created by charter is as an example of a situation where there isn't a statutory limit. I don't think I need to take up any time on that. So, foreign
Take it back. I mean, the assertion at paragraph 65 that the consequence of legal personality is that a person can do all those things which legal personality is required. Is that supported, or is that simply asserted?
It's asserted there, and then the analysis that follows is what is supported.
Yes, it seems to be saying, well, in all the domestic examples, unless you've got a company limited by its article or statute, then you can do anything you like. It begs the question as whether that applies to a sovereign state.
Yes. Well, what they're then saying is, well, when you take a sovereign state, having recognised it, and so given it legal personality, people with legal personality as a matter of English law have unlimited capacity, is what the Court of Appeal is saying, unless you can find something in a statute which limits it.
Yes, where do they deal with the question whether constitutional limitations in the sovereign state are relevant?
Well, the whole premise of what the Court of Appeal is saying is that the internal laws of a sovereign state are not relevant for this purpose.
Yes, I mean, that's the premise, but...
But that's yes, I mean, what they're saying is because as a matter of English law, the analogy in a way is, I mean, for instance, if I as an individual write down on a piece of paper that I will not enter into transactions exceeding £10,000, and I then go to a bank and borrow £100,000, as if I say, well, it's part of my internal law, my internal stipulation. And the question is that of any relevance? Now, as a matter of English law, what I might say to myself and write down on a piece of paper, might be something I tell my wife and she thinks is a good idea, but beyond that, it's legally of no relevance.
I mean, that's the analogy they're creating in the absence of any direct authority on the point, which may work both ways. I mean, so the fact that no one ever suggested that the powers of the capacity of a sovereign state is limited by its internal rules. The other side will say, well, no one's ever said the contrary.
Well, if your Lordship is saying to me, is there, as it were, direct authority on this? There isn't, and hence that's why one's able to have the argument. We rely on the Tin Council case as showing certainly the House of Lords proceeding on that basis. It's obviously not part of the ratio, but it is part of, you can see the reasoning in Lord Oliver. We rely on the history of the Diplomatic Privileges Extension Act, not because we're seeking to construe that act and not relying on the materials for that, but the materials that we've set out in our written case at 30 to 38 are what they show is what the views were of the various people involved at the time prior to 1994 as to the capacities of foreign states to act as a matter of English common law. So we're...
I understand all that, but I mean, isn't there a stronger point, possibly, I don't know, since the United States of America case in 1867, which sort of drew attention to this distinction between monarchs and non-publics. No, it doesn't seem that anyone's ever asserted in litigation that the capacity of a sovereign state is limited by its own constitution.
No one has asserted it. Now, respectfully, I mean, here we have a whole series of points, but I would suggest that particularly if you think about international bond transactions of that sort, for a state to pop up and say this sort of thing, I mean, I know this has the overtones of all the political dispute between between Russia and Ukraine, but if leaving that aside, for a state to make this suggestion would be a fairly extraordinary one. So your Lordship is right, no one has suggested this.
Mr. Howard, can you help me in that regard with Article 46 of the Vienna Convention on War Treaties, to which Mr. Thankey referred us this morning?
Yes.
Now, that, of course, is addressing relations on the international plane.
Yes.
But it does appear from that there may be limitations on the capacity of states, and indeed that may have an effect on the validity of a treaty if it's apparent.
Yeah, well, my lord, if one's looking at the position as a matter of public international law, the position is actually entirely supportive of the trustee, entirely. And let me just explain why. The position is that at international law, a state is regarded, obviously, as sovereign. That means that it can, as a matter of international law, do anything. So you see that in Oppenheim's international law, where it said sovereignty is supreme authority, means legal authority which is not dependent upon any other earthly authority. And then the Lotus case, which is cited by Lord Neuberger in Gul Mohammed, which is in Authorities 15 at tab 136, where the point is made that states have right to do whatever is not prohibited by international law. It's also the Brownley's Principles of International Law, which is at Authorities Volume 20, tab 194, which is that a state cannot plead provisions of its own law or deficiencies in that law in answer to a claim against it for breach of obligations under international law. The Upper Silesia case, I'm sure everyone's familiar with, which says that municipal laws are merely facts expressing the will and constitute the activities of the state. Now, the Vienna Convention, to get to that, what that actually provides is that it's in Core Volume 1, perhaps we should turn it up since your Lordship asked about it, at where is it? I've given you the wrong reference, sorry.
I don't.
Yeah, sorry, volume 19. And if you look at page 7635, and Article 6 provides that every state has possesses capacity to conclude treaties.
Sorry, where are you reading from?
Page
Yes, Article
763.
6. Yes, thank you.
Article 6. Then Article 46, which is on page 7637, which is headed Provision of Internal Law regarding competence to conclude treaties. A state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of its provisions of its internal law regarding competence to conclude treaties as invalidating its consent unless that violation was manifest and concerned a rule of its internal law of fundamental importance. A violation is manifest if it would be objectively evident to any state conducting itself in the matter in accordance with normal practice and in good faith. And what in our submission shows, firstly, Article 6 shows there is capacity to conclude contracts. What Article 46 is looking at whether or not you can justify your failure to perform. So it's not a matter of capacity, but of refusing to perform an otherwise binding contract. And Article 27, yes, on 7636, provides that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty without prejudice to Article 46. So what you actually see, if you're asking the competence question, the Vienna Treaty answers it unequivocally in Article 6, and then places limitations essentially on excusing your non-performance by reference to breaches of your internal law.
Well, 27 is concerned with performance, but 46 is concerned with the competence to conclude the treaty.
Well, you've got to read how 46 and 6 fit together.
Yes, this is my question. Is 46 not a limitation on capacity? You say, for example, in your written submissions that in international law there are no limits on the capacity of states, whereas Article 46 might suggest that there could, in certain circumstances, be such a limitation.
Well, in my submission, if you start off with Article 6. Article 6 is saying states have capacity. Article 27 then says you can't invoke the provisions as justification for a failure to perform.
Correct.
That's without prejudice to Article 46. Article 46 is then saying that in certain circumstances you can argue that your consent wasn't validly obtained, and that's what they talk about as invalidating consent. State may not invoke the fact that consent has been expressed in violation of a provision of its internal law regarding competence to conclude treaties as invalidating its consent unless that violation was manifest. So it's looking at a particular situation. But, I mean, at the end of the day, it doesn't, in our submission, one shouldn't get too hung up on this. All the other statements say a state has unlimited capacity to do whatever it can on the international plane. Here, either it's saying it does have that same unlimited capacity, or saying, well, there may be circumstances in relation to a treaty where you can pray and aid your own internal law. But it's in that very, very specific situation and in a very limited way.
You might perhaps add that as a matter of domestic law within the United Kingdom, there's nothing to support the view that there are any limitations on capacity. Or
Sorry, could you?
Yes, I'm sorry. You might add that, I suppose, I'm not saying it's right, you might add that as a matter of domestic law with which we're concerned, and according to your submissions, there's nothing to limit the capacity of a state as recognised by Her Majesty's government.
Yes, I mean, it's common ground that we are only concerned with the domestic position. So this is only relevant, as it were, as some sort of cross-check to see what the position is. No one is saying it directly is applicable here. And that was the reasoning of the Court of Appeal. But they were simply saying it would be odd if English law was out of kilter with the general position at international law. That was the point I was drawing your attention to.
Article 46, I suppose, might bite in the sort of situation we've had when some of the EU treaties have been concluded and some states like France or Ireland have had to hold referendums before they could sign up to the treaty. And so a state like France, for example, might be entitled under Article 46 to invoke its own failure to comply with its internal procedures as invalidating its consent to the treaty on the plane of international law. But really that's a different issue from the one we're concerned with, which is capacity under English law to enter into a contract.
Yes. I entirely agree with that. And what is the argument that in fact is made here? I mean, at the end of the day, it's a very simple argument, which is by Mr. Thankey, which is he says that you can draw an analogy between recognition of a state as a legal person and recognition of a foreign corporation or public body. Now, the difficulty with that is there is no such analogy. Firstly, because it appears to be common ground that the capacity of any entity is to be determined by the law that clothes it with legal personality. That appears to be common ground. And that same logic underpins the rules of private international law, which are contained in Dicey at Rules 174 and 175. And my Lord Hodge observed in the Investec Trust case, which is in Volume 1 of the Authorities at tab 6, at paragraph 84, that the common law refers questions of the legal nature of an entity to the law of the entity's creation. And again, that's all makes perfect sense. And that's what Mr. Justice Blair in the Court of Appeal meant by the capacities of an entity flowing from its personality. And that's, we've seen the paragraphs in the Court of Appeal that deal with that. Now, once one asks, what is it as a matter of English law that creates the state? It's plainly not created by its own law. On the domestic plane, it's English law that clothes it as a result of Her Majesty's government's recognition. Now, a foreign corporation is a subordinate entity created by the state. And so it makes perfect sense that as a matter of English law, when approaching a foreign corporation, one looks to the law that created it. And so principles of comity, when you apply them to a foreign corporation, through principles of comity, we are recognizing the foreign sovereign's power in creating and indeed destroying a foreign corporation. And so that is what comity means there. You respect the power of the foreign sovereign to set laws within its own territory and determine the powers of entities created by and under that law. I see the time. I haven't quite managed to finish this point, but I won't take long on it tomorrow morning.
Very well. We'll adjourn then and sit again at 10:30 tomorrow.